Good, I have the short chair. Good morning and welcome to this sitting of the Massachusetts Appeals Court. It is my great pleasure to be sitting today with Justices Nyman and Shin, and my name is Gabrielle Wolohojian. We are hearing 5 cases this morning. We'll probably take a morning break, but we don't know exactly when, but we'll give you at least one case's worth of notice for those of you who are waiting for the later cases. Otherwise, we're just going to go right through the list. For those of you who have been here before, I'm sorry to repeat instructions you already know, but I will mention that each side receives 15 minutes to argue. When you are a minute and a half from the end of your allotted time, the yellow light on the little display on the podium will light up so that you have a sense of the amount of time remaining and to wrap up your argument. And when the red light goes off, your time has expired, and unless we are continuing to ask you questions, your argument time is over. There is no rebuttal permitted, so don't reserve time for rebuttal. We have a couple of cases on the list today that are partially impounded. We count on counsel to keep in mind what is the impounded material and try to work your way around it so that if it's oftentimes names, we won't refer to parties' names, we'll refer to them by status, mother, father, whatever, husband, wife. But if it's financial information, please be aware of that so that we're not referring inadvertently to things in open court that are actually impounded. If it does slip out, please tell us, because we have a way of editing the YouTube video later on to take out the impounded material, but it's not easy, so it's better to avoid it if we can. You may construct your argument in any way you'd like. However, I will tell you that you do not need to spend your time, if you do not wish, educating this panel on the background facts of your case. I can assure you that we know them. We have read your briefs carefully. We have read large portions, if not all, of the record, so you can dive right into your arguments. You don't need to worry about educating us on the background. But as I said, you may construct your argument any way you wish. So with that, I am going to call the first case, which is 2022 P0612. James, is the name impounded? No, name's not impounded. James Wright versus Commonwealth of Massachusetts. And is it Attorney Keneally?
Yes, it is, Your Honor.
Great.
Thank you. Morning, Your Honors. May it please the Court, my name is Joseph Keneally, and I represent Mr. James Wright, the petitioner in this matter. I'd like to start with the first argument raised in this brief, which involves evidence of titles and alleged contexts of 2 books found in Mr. Wright's possession when he was attempting a kidnapping in 1994. Now, rather than simply re-argue the fact, the brief as it was set forth, I want to start from a different angle and acknowledge that this was, frankly, acknowledge the obvious. This was a difficult case for the petitioner. I think that Section 9 trials in general are fairly difficult to win. There's a win last week, I think, but other than that, I think there's been maybe 5 wins for petitioners since the pandemic ended. So these are tough cases, and for a lot of reasons. I mean, the obvious reason is the petitioner here was convicted of offending against 4 children. And jury has to determine whether or not that individual is likely to reoffend. And in the context of that, they're instructed that they're to consider the seriousness of the potential harm when someone is being determined whether they're likely to reoffend. So a jury can look at a case like this and say, if this guy's going to go out and offend against a child, 5% might be too high a risk. 3% might be too high. So it's a tough call. In addition, the rules of evidence are relaxed in this case, as this court knows. It happened in this case. I think in 2017, there's an allegation in 2017 that he possessed photographs of scantily clad young men, and that was presented to the jury as actually being true. Although, in fact, it was an allegation that was never followed up. No one ever found out what.
But, so I was confused about that.
Yeah.
There are photos in the appendix. Are those not the photos that were that he was found to be in
Those
possession
are
of?
the photos that were confiscated. My understanding of the record
Oh,
is...
are you, so there were photos in his backpack in the bus stop incident?
No, these are two separate incidents.
Okay,
The incident regarding the book titles was from 1994.
Right.
I'm talking about the photos that were allegedly found in his cell in 2017.
But are those not the photos that are in the
They're the
appendix?
photos that are in the record.
Okay.
Yes.
That's what confused me, because you said something that made it sound like
Right.
the jury couldn't have known that
My
those...
point essentially here is that this is a system where the jury determines how likely someone is to reoffend and where evidence of allegations is being presented to the jury as proof. These are difficult cases in any event due to the way that these cases are set up. And my
Are you
po-
saying there wasn't evidence to establish that those photographs were the photographs that were confiscated from his cell?
We don't know. I mean, those might have been photographs that were taken from the cell, but
Through whom were those photos admitted?
they were admitted as evidence of, there was an allegation that he possessed these photos, okay?
And
There was
then the
no
photos
evidence that-
came into evidence
And the photos came into evidence.
through which witness?
Cross-examination, I believe it was redirect examination of the cab witness, I believe, or it might have been one of the qualified examiners. In any event, the point here is that those photos, it was never determined that he definitely possessed those photos. He was alleged to possess the photos, and an investigation was undertaken, but there's no evidence as to what that investigation revealed.
Except that it did somehow reveal these photos.
Except that photos were found in a cell. He might have been with another inmate in the cell or something like that. But no one knows for sure whether he had them. But this was being passed off, and these photos were presented to the jury as if this is fact. This is kind of like, the point here is when you have evidence of allegations being passed off as proof in cases like this, it makes it extraordinarily difficult. But these are the rules. This is the playing field in these cases.
Can
And
we go to the book titles?
Yeah, well, my point was in the context of all this, in the context of how hard it is to bring these cases to trial for a petitioner, why in the world would we be talking about John Wayne Gacy? And why in the world would we be talking about serial murder and torture of children?
Well, let me ask you a preliminary question about
Sure.
the books. Was the issue preserved? And the reason I ask is because at the trial transcript, pages, at least record appendix, pages 487 and 488, there's a discussion about this. A motion in limine had been filed on behalf of your client to exclude them, I believe. And at page 488, Mr. Smith, who I believe was your client's attorney at trial, says, and this is lines 21 through 24, but at the same time, mentions John Wayne Gacy, so is the content of those texts, so if it's talked about, it's admissible, I think. So I feel like I'm defeated on that.
Yes,
So it seems to me that if that's the case, it's either waived, or if in these cases there's no waiver, then it's a substantial risk standard. Is that correct?
that would be true, Your Honor. But I direct the court to page 634 of Volume 1 of the brief. I believe that was during the cross-examination of Greg Bell, the cab witness. And at that point, Mr. Smith got up, prior to these book titles and book contents being introduced, and wanted to renew his objection to the
But
introduction
he
of these
didn't,
books.
at that point, he didn't articulate the basis of the objection. It was just kind of a...
think-
So I don't know how the judge was on notice of the argument you're raising now.
I think he had a two-part objection. The first was that they were not relevant. And the second was even if they were relevant, they were far more prejudicial than probative.
So
Go ahead.
you read the objection at page 634 to be renewing those objections, even though earlier he had essentially conceded that the evidence was admissible?
I think he conceded at the point where counsel for the Commonwealth indicated that Mr. Wright admitted that he had these books. And for some reason, I think he believed that simply because Mr. Wright said he had these books, that now everything came in.
It was because the initial objection was that if the titles came in without any evidence as to what the books were about, the jury could just speculate about the content of the books. But once the Commonwealth came forward and said that there's evidence that the petitioner admitted that one of the books was about John Wayne Gacy, at that point, counsel said that would be admissible. So
I'm not sure, Justice Shin, whether or not that makes this evidence relevant, because he said it.
Okay, but we're talking right now about whether the issue was preserved. And is there anywhere in the record you can point us to where the argument you're raising now, which is that the Commonwealth was required to put in evidence tying the books to his mental condition, was that ever raised to the judge?
Pardon me, I'm sorry.
So the argument you're raising now is that the Commonwealth had to put in evidence tying the books to the petitioner's mental condition in order for that evidence to be relevant. Was that argument ever raised to the judge?
Essentially, the judge was the one who brought that up, I think, on page 487 of Volume 1, that he thought that, like he said, the book titles themselves weren't just going to come in. It would be too speculative. There had to be some reason for the experts to say that they had explored these books, considered them, and made some determination as to whether or not the book titles and the contents were somehow relevant to Mr. Wright's dangerousness and risk of reoffense. That's what the judge said. At that point, I believe counsel for the Commonwealth said, well, he said that the books were about John Wayne Gacy. That doesn't, in my estimation, automatically make this admissible. There still has to be some basis of relevance for this to come in. Mr. Wright could have said all sorts of things that had nothing to do with this case, but if it's not relevant, it doesn't come in. Correct, Mr. Smith said, in fact, I do feel like I'm defeated on this.
The titles divorced from the contents of the books may or may not be relevant, but the titles connected to the contents of the books, I'm having a hard time understanding why they might not be relevant. I mean, if they were two cookbooks, then I could understand an argument that they're not relevant, right? I mean, in this inquiry. But they're not two cookbooks. They're books about specific types of crimes. And the crimes are related to the types of crimes that that Mr. Wright has committed. So why is the fact that that's the reading material in his backpack not relevant?
Well, I think that if it was going to be relevant, it would be relevant by virtue of some sort of testimony from a psychologist linking the possession of these books to a mental disorder. I believe that that's a psychological sort of determination that needs to be made, because otherwise, anybody walking around with a book about anything, John Wayne Gacy, Stephen King's It, or anything like that, to say that that reflects their behavioral proclivities is making a leap that I think is best left to the experts who testify in these trials. And to simply say, book about a bad guy, he's a bad guy, he wants to do the same thing, that's where the judge called this speculative, I think. That's what the judge said that this was overly inflammatory and it was too prejudicial, because there was no connection made by anybody. I mean, in retrospect...
But that's a different prong. I mean, that the undue prejudice outweighs the probative value. That's a different prong.
For sure.
I actually... Are you arguing that there's no probative value?
None.
None.
Yes, I'm arguing there's
Okay.
none. If this is to show that he had pedophilic interests, there's evidence that he abused 4 children. If there's evidence, if they're looking for demonstration that he has antisocial personality disorder, he has an entire record of misconduct. It's all there.
why isn't it relevant simply as part of the narrative of what happened in 1994? I mean, there was evidence about everything that was in his backpack, some of which was maybe more inflammatory than others, but I mean, there was evidence put in that he had a Garfield writing pad.
Right.
So why isn't that relevant just as part of the narrative?
I'm not sure the fact that it was a Garfield writing pad as opposed to a cookbook or a writing pad with Charlie
So
Brown.
let's say he had a cookbook. I mean, so that comes in as part of the narrative. It's relevant for that purpose, right? So then the question becomes whether the unfair prejudice of whatever it was outweighs the probative value.
I guess if we go back to relevance, I would say what does the titles of these books or the contents of these books prove?
So when describing what was in his backpack when he was arrested in 1990, or
Yes.
he was arrested, right? They had to redact portions that were not like the All-Star Dad T-shirt. I mean, you have to go through and redact portions of the report. I mean,
Well-
it's all part of the picture, right?
I think that an argument could be made if counsel wanted to, that the fact it was a Garfield notepad as opposed to any other cartoon character notepad is not relevant, and that could have been redacted, but there
Why
wouldn't be really
isn't
much
it
point in it.
relevant? He was, there was reference to Garfield in the letters he was writing to the
Well,
young boys.
Fair enough, and that might be some sort of connection. I think that's...
So if that's a connection, then why aren't the two books a
Because
connection?
Mr. Wright never tortured or what, and his history has nothing to do with this. And maybe the point here is that this is, if we can discuss relevancy, but we also have to take into consideration whether this is more prejudicial than
I
probative.
think, to be frank, that would be the better argument for you.
And like I said, if evidence is content and these book titles move the ball down the field at all, it's nothing that isn't being done by the evidence that was presenting at trial in this case anyway. It doesn't demonstrate that he had pedophilic interests. We know that. It doesn't demonstrate that he had criminality in his behavior. We know that as well. So what is this getting us that makes it so probative that outweighs the fact that now we're injecting an element of child torture and murder into a case where an individual has not acted that way? Now, the Commonwealth suggests that there was a situation where he brandished a knife against a child and that he punched another person, but that's a whole factor of difference in terms of what we're talking about here. And like I said, going back to the risk, when the jury has to determine what likely means, they're going to consider what kind of harm this man might commit if he were to be released. And when you start talking about torturing children, and you start talking about murdering children and serial killers, you're adding something to this mix of things the jury is going to consider that's unwarranted. And for those reasons, it was improper to introduce this as evidence. I know I have a minute left. I will suggest the second part of the argument involved ineffective assistance of counsel. I think that in the issue of the photographs taken at the visiting room, 2 experts said that involved pictures of children, did not. Counsel should have addressed that. Unless there are any other questions, I would refer to the brief. Thank you.
No, thank you. I don't see any other questions. Thank you. Is it Attorney Holmes?
Yes, and good morning. May it please the Court, Jean Holmes for the Commonwealth. There's no cause to disturb the jury's verdict that James Wright remains a sexually dangerous person. As it relates to the books, the trial judge very carefully, and I would suggest cautiously, reviewed the issue of the admissibility of these books. In fact, there were hearings that took place over 2 days. And initially, the judge was concerned just about the titles. But once the judge was presented with the evidence that would be put forth at trial and was put forth at trial, that Mr. Wright had acknowledged in 2019 that he had possessions of the books, that one of the books was about, and these were his statements, Mr. Wright's statements, it was about torture and killing and luring children, 33 young men and children. The judge then concluded that as long as the Commonwealth connected the titles and the content of the book with Mr. Wright's statements and acknowledgement, with all of the other evidence, including Mr. Wright's brandishing a knife to one of the victims in 1991, as well as with his threats of violence, that they were admissible. I would suggest in this...
I think what's troubling me is the balancing of probativeness and prejudice, because the books depict, I haven't read them, but from what I can tell from what's described in the briefs and the records, they depict crimes of, let's just say, a different level of depravity than are presented in this case. And how did the judge take that into account? Is there something in the record that shows the judge took into account that there's a different type of case depicted in those, or crime depicted in those books, and whether what was the risk that might flow from presenting that to the jury without some expert testimony, let's say, to tie it as being, someone who's interested in reading those books is more inclined to do X?
And certainly that was not the evidence that someone's inclined to read those books would do X, Y, or Z.
So then how is it more probative than prejudicial?
In many ways. And it starts with the fact that Dr. Rousseau testified that, in her opinion, Mr. Wright was a violent pedophile. You combine that testimony, which she said in 2012, as well as during her testimony, with the fact that Mr. Wright had escalated his behavior. In 1991, he brandished a knife to a young man and then let the young man go. He further, in 1994, however, approached and lured and groomed 2 young boys that were 10, 11 years old. And he gave them a false name, and he convinced them that they needed to pretend that he was their father, and that he conjured up this event where the boys were to meet him the next day at the bus station. That is a far more egregious an escalation of the behavior. And the books go to the fact that he had those books and he had knowledge of the contents of those books certainly goes to the evidence of whether this was just a random act, or was this something that he was intending.
Let's say he had movies, or any of us, was pulled over, someone went through our backpacks, and we had stubs from a movie for a horror movie, serial killer movie. Does that, in your view, help establish anything about the likelihood of any of us committing a crime such as was in the movie?
Possession alone of the books would not, Your Honor. It is the combination of all the other evidence that includes Mr. Wright at the time that he was supposed to meet the boys, at the date and location where he was to meet these 2 young boys that he had already provided with false names, and he was going to take them on a bus away from their home, that he had not only the books, but he also had pornographic videos. He had 15 pairs of child underwear in the duffel bag. Underwear was a very big theme in all of Mr. Wright's offending behavior. So that it ties into his ongoing, and I would suggest escalating activity, that he had knowledge of these books and had the other paraphernalia. He also had an All-Star Dad t-shirt, which was part of the lure that he used for the boys, because the boys were to call him his dad on this trip that they were taking on the bus. This was all part of the background. So it wasn't just somebody who had a book. And
was the theory that the book was I don't understand the connection you're trying to draw. Was the book supposed to be a manual of some sort? What was the inference that the Commonwealth was seeking to have the jury to make from the fact that these 2 books were in the backpack?
That the book was about the luring, torture, and children, that Mr. Wright had a pedophilic interest, a deviant sexual interest that was prolonged and enduring, that all of the witnesses talked about. And not only that, but that his behavior was violent towards children, had been in the past, and was still currently, at the time that he was arrested, he still was demonstrating a current interest in violent behavior with children. So that is all relevant, and as far as if there was any error, it was certainly a slight error, given the overwhelming evidence in this case, given the fact that, in fact, the books were testified to once by one of the witnesses. It wasn't that the Commonwealth repeated that testimony throughout the trial. In fact, the mention of the books was not made in the closing arguments. So if there was any error, it was certainly very, very slight and certainly not unduly prejudicial under all the facts and circumstances of this case. As it relates to the photographs that counsel talked about, those were admitted through one of the qualified examiners. They were part of an incident report. Under the law, incident reports are admissible. And as a result of incident reports being admissible, so wouldn't all of the evidence that goes with those. So those were clearly admissible. Again, and that was as to Mr. Wright's current interest, deviant sexual interest, particularly as it relates to children, as well as his antisocial personality disorder and his antisocial traits. As far as ineffective assistance of counsel, in this particular case, counsel had a very difficult case. The Commonwealth called received testimony from 7 experts, called two qualified examiners, a CAB expert, and that CAB expert testified to not only his own opinion, but as well 4 other qualified or psychologists that offered their opinion.
There was no motion for new trial filed in this case,
And there
correct?
was no motion for new trial. And respectfully, there probably was no basis for a motion for new trial in this case. In fact, I would just like to make a slight correction. Counsel says that Mr. Smith, Attorney Smith, did not cross-examine Dr. Rouseware about her misspeaking that they were pictures of children that he had in 2000. And that was not correct. Counsel did cross-examine, albeit gently, he cross-examined Dr. Rouseware about that, and she testified on cross-examination that she had misspoke. It was men, and that is understandable. It was a trial tactic and a good trial tactic because Dr. Rouseware was the most favorable, although not ultimately favorable to Mr. Wright, but was the most favorable in that she offered some positives as it relates to Mr. Wright, in her opinion that Mr. Wright was being enthusiastic in his beginning to approach treatment. So based upon all of the trial strategies and reasonable tactics that Attorney Smith took, there was not ineffective assistance of counsel. And if there's no further questions, Commonwealth will rest on its brief.
Thank you very much.
Thank
Thank
you.
you both. You both presented able argument and good briefs, and we appreciate that. The case is submitted. The next case is 2022 P0757, Keith Soar versus Kimberly Lim. Attorney Mason.
Good morning, Your Honors.
Good morning.
My name is Attorney Morris Mason, 147 East Merrimack Street, Lowell, Massachusetts. I represent the plaintiff in this matter, Mr. Soar.
I think
Also,
you're going
no.
to want to adjust the microphone a little, and
Closer
then there's never any substitute for projection.
Thank you, Your Honor. Again, I represent the appellant, Keith Soar, in this matter. I would like to just take a moment to go back to the deed in question here. I know it's been specified in the decision, but it's a deed that's sort of unique. In 40-plus years of practice, which included quite a bit of real estate, I never saw a deed that was drafted that way. It was drafted by a non-lawyer, was never reviewed by a lawyer. The testimony at the lower court indicated that Mrs. Lim had never seen the deed and didn't understand why it was done that way. The testimony was that my client had not reviewed the deed, did not look at the first page, but merely signed. It was a deed that called for a payment of $40,000 on June 9th, 2014, and the remaining $40,000 to be paid by June 9th, 2024, 24 months. It did not specify anything that would happen if that was not paid. In this case, it was not paid.
So you are not arguing that any of the judge's factual findings after trial were clearly erroneous?
That is correct, Your Honor. I think she's applied the wrong law in this case, this
Okay,
situation.
so, and I didn't see the deed in the record appendix.
It was referred to in the decision.
Right.
Verbatim.
And
It's in the
that's,
appellee addendum.
so, so what do you do with the fact that the traditional language of, for example, so long as, is missing from the deed?
I think, Your Honor, if the persons who prepared the deed had not suffered through the first year of law school real property with the innumerable ways that could be determined, you go by the plain reading of the document. In this case, it says you pay this amount this day, this amount by this date. Any type of contract, if you don't pay the second amount, the contract's not complete.
So I don't understand that. That sounds to me like you're arguing for a change in the law.
No, I don't believe I am, Your Honor. I'm arguing that the plain reading doctrine would apply here, based on the fact that there was no expertise on the part of my client in looking at a document and knowing what it would mean. And there was no apparent expertise on the part of the drafter.
Right, but how does that help? Because if they don't include the required language, they just don't include the required language.
Well, I'm not sure it's required, Your Honor. That's the question that we ultimately come to in this case. If you take the plain reading document and you look at contract law, I don't think it's required. I think it says, okay, if you don't make your second payment, when the car's not yours.
Well, isn't
Case-
that, because the usual language is not there, doesn't that create an ambiguity in the, and if so, doesn't that
Justice
become...
Nyman, it does exactly that.
But doesn't that become a finding for the judge to make, as opposed to, I mean, how as a matter of law can we resolve that? Isn't the judge required to make findings of fact, and that's what she did here?
In this case, if you read the ambiguity, it should be read against the drafter. That's the longstanding tradition in Massachusetts and I believe in most of the country. The only exception, I believe, is Louisiana. But if you read that against the drafter, it doesn't create any conditions. It makes it basically a situation where if you don't pay the second, you don't have a deal, if you don't make that second payment. When we get into...
Are you saying that fact finder needed to make some conclusions about what the party's intent was?
I think what you have to do is following the doctrine of, if there's an ambiguity, read it against the person who drafted it. Yes. This document was drafted by the defendant's brother, who we, at testimony at trial, indicated that she acted as her agent, and she would be bound by any actions he took as her agent. The ambiguity is there. The ambiguity is such that if you cannot determine what would happen, you look at the plain reading of it. The plain reading of it is second payment isn't made, there's no deal.
And what is the specific language you count on in the deed for that reading?
That would be that the first payment was due then, the second payment was due 24 months later, which would be June 9th, 2016, and it was not paid on 2016.
And so what would we do with our cases that say you need, I don't want to call it magic language, but I want to say, particular language?
I think that becomes...
In order to create a fee simple determinable.
That becomes a situation where everybody has been indoctrinated in property law from the first year of law school that these estates exist. This may be a time to determine that these estates, unless specifically provided for, don't exist. If you have a plain reading of a document that says...
Okay, but we can't change the law. That may be an argument you could make to the Supreme Judicial Court, but we are going to have to deal with the law as it exists.
And I think within the context of the law as it exists, the plain reading of the document says it's certain things are to be done by certain dates. If they're not done, it's not completed.
Do you agree with the judge's determination that you had the burden of proof in this case?
Yes, I do, Your Honor. So if we look specifically at the document, how it was drafted, who drafted it, what it says, I think you can see that it's a clear document if you're a non-lawyer. And that's in fact what occurred here. As far as I can tell, and as far as my contacts with my client, no lawyer ever looked at this document. If they had, they would have raised the same issue that I believe this court has raised. What happens?
Well, maybe they would have revised the document before it was signed.
I'm sure they would have. I know if it had been brought to me beforehand, I would have. But it wasn't. And that's where it goes back, where you have individuals who are not trained in the law, who have done something based on what they considered to be a plain reading of it. It didn't occur.
If the document had come to you, what specific change would you have made? I'm sure you might have made a lot of changes, but with respect to the issue you raised, what would you have done?
I would have specified what would have happened if, in fact, I would have, first of all, stated that this creates an ambiguity, and we've got to resolve the ambiguity. And to resolve that ambiguity, I would have relied back on property law to make it into a fee simple determinable.
So you would have at least
Clear.
added language to the effect of what would have happened if the payments were not timely made.
If that's what the understanding between the parties was, yes.
Okay.
I think that would have clarified it and saved everybody a lot of time, trouble, and expense. But that did not occur.
Can you tell me what the status is with the $40,000 second payment?
The second payment is being held in escrow by my brother and myself.
Okay.
It was timely made per the court's decision. It was never made prior to that.
Is the $40,000 subject to, in the judgment, subject to interest?
If I may.
Well, we can ask your
No,
brother counsel that question
I
later.
believe it's a non-interest-bearing account, Your Honor.
Is the judgment, though, subject to interest?
Yes, it is.
Okay.
I believe it would be, as any judgment would be. I'm ready to answer any other questions that the court may have. If not, I would just express my gratitude for my brother for his cooperation in this matter, and just tell him I'm glad to see him here. He's had a severe physical injury prior to this. Thank you, Your Honor.
Thank you.
Thank you. Attorney Lindauer?
Good morning, Your Honors. My name is Kenneth Lindauer. I'm from Salem, Massachusetts. My position is, I think, clearly stated in my brief, and which incorporates the judge's decision in this case. It's my understanding from the judge's decision that there is no ambiguity in the deed. It's a deed signed under seal and was notarized and recorded, registered at the registered land.
What is the point, then, of having a payment date in the deed if it can simply be ignored?
Well, the original understanding was that my client would make the second payment in 2 years. She offered to make the payment after the 2 years elapsed. The appellant was in bankruptcy at that time, and I think that testimony in the court indicated that she didn't know how to make the payment since he was in bankruptcy. He was in a Chapter 13, I believe, and she hired an attorney at that point to make the payment, which was refused. It was refused a second time and subsequent times as well. And as you indicated before, the money is being held in my IOLTA account pursuant to an agreement with Mr. Mason. I think the appellant's argument here would create havoc within the recording and registration system if his argument is that the plaintiff didn't understand what he was signing. I think then any deed that's recorded later on, a conveyor of property could indicate, oh, I didn't realize I was signing a deed, or I didn't realize what I was doing, or I didn't see the first page of the document. and then every document on record would be subject to some question. The law in Massachusetts, I believe, and based on the case law that the judge cites and that I cited in my brief also, is very clear about fee simple determinables, that there has to be specific language to indicate that. And in this case, there is none. I believe that the appellant's remedy here would be a remedy in law, which would be the payment of the $40,000, which the judge accounted for in her decision, in which we are holding in the event that the appeal is unsuccessful. I really have nothing further to add. I don't know if you have any questions for me. No?
I don't see any. We have your briefs.
Thank you very much.
We thank you. It's an interesting case, and we appreciate your briefs and your argument. With that, the case is submitted.
All right, thank you very much.
I just, do you think they're going to take it? Okay, we're going to take a morning break after this case. So for those of you who are waiting, just so that you know, after this argument, we'll take a break of about 10 minutes, 15 minutes. The next case is 2023P0210 in the matter of, it says Olson, Jean. Is it Attorney Lee?
Correct, yes. Good morning. May it please the court, Brian Lee for the appellant, David Parker. We're here today relating to the petition to probate the will of Jean Olson, devising her $1 million estate. This will is in every way a complete and proper will, undisputedly reflecting Miss Olson's testamentary intent with one issue. It was signed not by Miss Olson, but by David Parker, a court-appointed conservator and guardian, who was, per order of the court, had assisted Miss Olson in preparing her will. Mr. Parker's signature
Was, I guess in the big picture, I would like for you, within, let's say, 7 days of today, to file with the court here all the papers in the conservatorship action. Until then, I have a couple questions for you. Was the conservator's application for fees in that conservatorship action approved before or after the signing of this document?
As to in the conservator action, not in this petition, right, where there was...
That's right, in the
I am not sure as I sit here today, Your Honor.
Okay. So if you'll file with us everything that was filed in the conservatorship action, I'd appreciate it.
Of course, I will. Thank you. It's undisputed here that Mr. Parker's signature is not valid under the law. However, the will is still valid under the plain and unambiguous terms of Chapter 190B, Section 2-502, which sets out an exception to its execution requirements. This exception reflects a modern principle that issues with execution do not defeat intent. Section 2-502A states, except as provided in subsection B, and it then goes on to list the execution requirements, including that a will has to be signed by the testator or in the testator's conscious presence.
So are you arguing that the requirements of A1, A2, and A3 are all subject to this extrinsic evidence exception in subsection B?
Yes, Your Honor.
So under your interpretation, must a will be in writing, or would the exception apply to that as well?
It will because of what subsection B says, which subsection B says, intent that a document constitute the testator's intent can be established by extrinsic evidence.
The document need not be a writing or have writing on it.
I think it need be, Your Honor. I do think a document, as that term is understood, contemplates something written, something tangible. It is not an oral statement. It is a physical document.
Then why didn't the legislature have sub B apply just to subparts A2 and A3? Why did they have it apply to A1 as well?
Well, Your Honor, I do think, I think the way this, so it's my position, right, that we don't even need to get to the UPC. We can apply the plain terms of this statute. We can
I'm
look
talking about under the MUPC, to be clear.
I'm sorry?
I'm talking about under the MUPC, just to be clear.
Correct, and I'm attempting to use an analogy here, which is that under the UPC, it also has the same except as provided in subsection B language, and the subsection B in the UPC is for holographic wills, okay? And holographic wills, it says that those are permitted, and then it also says, though, that those holographic wills still need to be signed. So in that example, right, in the UPC, they use subsection B to specify where one of those part A1, 2, or 3 is still required. There is no similar language in our subpart B. All we have is except as provided in subsection A. And so I would argue that under the plain language of the statute, there is no way to give meaning.
But I guess that doesn't answer my question, right? So your fundamental argument is basically that it kind of doesn't, subsection B kind of doesn't apply to A1 because it says document. But then why did the legislature draft the exception to apply to A1, A2, and A3? We have to read it as applying to all three, don't we?
I think it applies to it, Your Honor. I just think when you're in the subsection B exception, it still has to be a document. And so the practical result of that is that it still has to be.
It's always going to be in writing.
I'm sorry?
So then what you're saying is it always has to be in writing.
Right, because of what's stated in subsection B, though, not because of what's stated in subsection A.
Okay.
So in your view, are holographic wills valid in Massachusetts?
It's a great question, Your Honor. On their face, no, because you need extrinsic evidence, right? This exception.
Okay, so what becomes of subsection A, if you're correct, your reading is correct?
So what becomes of subsection A is what we have here is just simply a situation where a recognition that a signature is not the end in itself. Okay, so a signature is a good, well-established way of recognizing that a person intends to be bound by a document. A signature is not
It serves important purposes, right?
Of course,
To prevent
Your Honor.
fraud and,
Of course.
Okay.
A signature, though, is not infallible. There are, of course, instances of fraud and duress and other issues. And by the same token, a signature is not the only way a person can express their intent to be bound. I would argue that this
what would be your
is-
burden of proof if a will could be proved valid by extrinsic evidence?
It's preponderance of evidence in this statute.
So even though the legislature chose not to include the harmless error provision, which adopts a clear and convincing standard, you're saying that the legislature's intent was to adopt a preponderance?
It undisputedly did not adopt 2-503 as that is stated in the UPC. It did not adopt
So
a clear
it rejected a provision that would impose a demanding standard of proof in favor of this catch-all exception to which a lower standard of proof would apply?
Well, Your Honor, I do think that what we see in the subsection B language is very similar to what we see, except for the burden of proof, is what we see in the harmless error provision. Both of those require or provide that a document not executed in compliance with 2-502 is still valid where evidence establishes that the individual intended for that document to be their will. That's the same thing that our exception does here. It does not do it on a clear and convincing evidence standard. It does it under a preponderance of evidence standard. But that is,
I mean, subsection B is almost identical to UPC subsection C, taking out the holographic wills language, right?
And I would argue, Your Honor, that subsection C in the UPC was adopted for an entirely different purpose. And is specific to holographic wills, right? It was adopted in response to the estate of Foxley case out of Nebraska. This is reflected in the commentary to.
But it's not limited to holographic wills. Subsection
Correct.
C.
That is the purpose of why it was adopted, though, Your
Right,
Honor.
so I mean, it almost seems like there's a drafting error in the MUPC, but at a minimum, isn't subsection B ambiguous in that it could be meant to apply to a situation where the testator's intent to make a testamentary disposition is at issue, as it was in the, I forget the name of the case you just cited.
Foxley case?
Yeah.
No, Your Honor, because there is no way to give meaning to except as provided in subsection B without recognizing that there's an exception stated in subsection B. And I would note, Your Honor, that Your Honor just raised the possibility of a drafting error. I would say that there's nothing in the statute that indicates it was a drafting error. It makes complete sense. It aligns with the type of exception that is provided in the UPC's harmless error provision. On top of that,
The UPC also had the except as provided in subsection B. Subsection B had to do with the holographic will, so that makes perfect sense to me. And then subsection C has the same provision about extrinsic evidence. So I don't know, it seems to me there could have been a drafting error in that subsection B was removed, but the except as otherwise provided was accidentally kept in.
well, I would say to the extent, so what we have to go on is the term, as to the legislator's intent here, is we have the plain language of the statute, and we also have the purpose of the statute. Section 1-102 lays out the purposes of the statute. One of those stated purposes is to discover and make effective the intent of a decedent in distribution of the decedent's property. That's exactly what this exception does here. It allows for this court to reach the right result in these types of cases.
You mentioned commentary before. When you said commentary, were you referring to the MCLE commentary?
No, I was referring to the commentary in the UPC.
In the UPC?
Correct.
Okay. Quick question. Is there any commentary or legislative history you're aware of discussing why Massachusetts declined to adopt 2503, the harmless error provision?
No, there is no legislative history here that provides any guidance.
Aware of any commentary or
No,
authoritative treatises or anything else?
I am not. The only commentary that I've ever seen is a commentary my brother cites, which is not an official commentary, it is an MCLE. So I think the answer is no. I do want to come back to this point briefly, though, that I do think that this statute not only is in conformance, adopts the same principle that is in the harmless error provision of the UPC, but allows this court to reach the right result in these types of cases. In this case, Ms. Olson wanted her last act to be to give back to the charities that had helped her and her family through their hardest struggles in life. The Boston Children's Hospital had cared for a disabled son. The Masonic Lodge was a very important part of her family's life, including after her husband died. She also wanted her nieces-in-law and her nephews to benefit, but in specific amounts and for specific reasons. I would argue that the law should and does under 2-502 allow for these wishes to be carried out, even though she didn't sign her will.
So this case doesn't push the boundaries, as you say in your brief, but is there any way for us to write a rule that would apply only to this case?
I think, Your Honor, so these are going to be very fact-specific cases, right? So it is hard to write a rule that captures.
The rule that I think you're proposing would allow anybody to at least get their foot in the door. I mean, I could present a cocktail napkin with written in magic marker, not signed or witnessed, and say this is a will, right? That would be the rule.
I think any document, you need a document where you have extrinsic evidence where you can prove by a preponderance of the evidence that the decedent intended for that document to be their will, yes.
Or intended it not to be a will, right?
Or not to be a will, exactly.
I just want to make sure I understand. This came up in the context of a motion for summary judgment?
Correct.
So the question would be whether there was, in this case, sufficient evidence to get over the summary judgment standard with respect to the question of intent.
Exactly.
Even were we to agree with your legal arguments, we would not actually be concluding that this will was a valid will,
That's
right?
correct, Your
We
Honors.
would just be remanding for a
That's correct,
trial
Your
on
Honors.
the question of what the decedent's intent actually was?
That's correct. And I would note that I think in the estate of, I think it's estate of Atia, which is not actually in my brief, but is, and I'm sorry, I don't have the citation in front of me. It is a Michigan appeals court case. That was the exact situation that the court had. It was a summary judgment decision. The issue of law was raised in Michigan for the first time under the harmless error provision, which is modeled off of the UPCs in Michigan. And the court assessed that issue, determined that under the harmless error provision, which I would argue, again, has language very similar to our provision at issue here, that unsigned wills could be validated based on this extrinsic evidence. So it made the ruling of law and remanded back to the lower court to decide the question of fact.
Can you help me understand the relationship between the various lawyers who were involved? So the conservator was appointed by a judge of the probate and family court.
Correct.
It was the same judge who ruled on this motion, correct?
It was not,
It
Your
was
Honor.
not? All right. And the request for conservatorship came from, initially, was it a facility in which the decedent was living?
No, it's Old Colony Elder Services, which is an organization that provides services to elderly and disabled individuals. They had heard, I'm not sure this is in the record, it will be in the conservatorship record I submit, they had heard that Ms. Olson was being taken advantage of financially.
Okay,
and
so some organization came to the court. The court then appointed your client.
Correct.
Now, in some kind of, I'm trying to understand the relationship between the conservator and the decedent in the context of attorney-client. It's not an attorney-client relationship, is that correct?
That is correct, Your Honor.
Okay, so then I understood from the record that the decedent also had her own attorney.
Correct.
Was that part of, that just existed independent of the conservatorship?
To some degree, it was a little complicated because the attorney that represented Ms. Olson also represented Mr. Grezik and her sister, Ms. Olson's sister. And so because of that, she wore multiple hats. But she did object to this conservatorship. The judge still continued it and appointed my client as the permanent conservator over those objections. She was a part of at least one of these meetings where they sat down.
Okay, but she's then, so the conservator, the decedent is not actually the client of the conservator. The conservator is acting in the decedent's stead, I take it? Or at least, well, you'll straighten me out. And then there's another attorney who actually drafted the document. And who was that attorney's client?
It's a good question, Your Honor. I'm not sure there's a clear answer because what she did is my client reached out to her on behalf of Ms. Olson as part of this order that my client was supposed to assist Ms. Olson in preparing her estate plan.
So is the conservator an agent of the, I'm trying to I need to obviously do some self-education too, but I'm hoping you'll help me. What is the relation, I don't see the conservator's relationship with the decedent as one of attorney-client.
I would agree. I would agree with that.
Okay, so is the conservator acting as the agent of the decedent in lieu of the decedent? How would you explain it?
I guess what I would say is the UPC changed things where it contemplates that a conservator can actually hold title to the property that for the person he is representing. It's complicated here because I'm not entirely sure that would be the case, because I do think there are certain findings that the court needed to make in order to get into the 5-407D scenario, which we do not dispute did not happen. So he either served in that capacity, or if he did not, he certainly was appointed by the court to assist Ms. Olson, to look out for her, to be her advocate here in carrying out the tasks he was required to do.
But following up on Justice Wolahojan's question, is the role of a conservator defined either in the MUPC or in the common law?
Again, I think it speaks to powers that a conservator may have. I'm not sure it defines, and I just don't know the answer. I'm sorry.
They're really defined by the judge in the order.
I agree with that, yes.
And I understand part of your argument to be acknowledging that either the conservator and/or the lawyer who drafted the document to either have made a mistake or to have misunderstood the law when they signed it rather than having Ms. Olson signed it. Is that correct?
Yeah, so the reason why my client signed it is not expressly stated. I think it's reasonable to infer this from this record, that there were a number of attorneys at that time that thought that the
That was the
conservatorship
appropriate
decree
mechanism.
provided my client with authority to sign it on her behalf. I see I'm out of time, so unless...
Yeah.
Let me just check for questions. No, you sure? Do you have any more questions? No. Okay, thank you. I don't see any more questions. Is it Attorney Bowyer?
Yes, Your Honor. Attorney Matthew Bowyer, representing the objector, Anthony Lewandowski. At council chair with me is John Giannino, who represents the other objector. He will not be speaking today, though, I suppose, unless you had some direct questions for him.
I take it that if we were looking at this solely through the lens of ordinary summary judgment, where if the question were solely what is a person's intent, that this factual record raised a sufficient question of intent to go to a trier of fact.
Judge, I think that there is sufficient doubt as to what the testamentary intent of the decedent is that the matter should go to trial, and in fact, if remanded from this court, it would go to trial. I can, off the top of my head, think of a dozen ways in which the testamentary intent and the actions would be attacked. Obviously, this is summary judgment on a point of law, and so those are not really material issues. That's why, as I noted in my brief, I haven't been arguing them. They're not material to
Right,
the
so I
summary
just
judgment.
wanted to, though, make sure I understood the state of play, that as in your view, this is purely a legal question, because if we were to get into the question of fact concerning intent, you would agree that the case is one suitable for trial rather than that could be disposed of on these papers.
It would have to go to trial, Judge, because it's not only testamentary intent, it's actually testamentary capacity as well that's at issue. In fact, there are a number of issues. There would probably be issues of undue influence or coercion. You know, I just take, for example, the language of that limitations. Forgive me one second. You know, the order says a financial and estate plan be established for Gene Olson. It doesn't say by Gene Olson, it says for Gene Olson. So that in and of itself, combined with the various affidavits, the affidavit of the conservator, the affidavit of the attorney who drafted the will, the language in the will itself, all suggest that this was done in contemplation of the 407 exception to...
And why can't this document that was ultimately executed by the conservator be construed as an estate plan?
Well, Judge, the thing is that in order for it to be approved under Section 407D7, 5407D7, there has to be notice. There has to be an opportunity to be heard. As we know, there was a pre-existing will. All of those people are entitled to notice, as are the heirs at law. No one got notice, Judge.
But that could still be done, correct? That could still, because that could still be done in the existing conservatorship action.
Well, I don't believe so, because the conservatorship ends on the time of death. So there is no longer a conservatorship action. If there were,
Okay, but
Judge.
so the person who was the conservator, though, could file a general petition.
Well, but again, I don't think that, this is a very specific statute. It's not common law. It's not drawing on a number of cases. We have a very specific statute that sets out that the court has authority to create a will or amend a will or revoke a will under the following circumstances: notice, due process, substituted judgment, hearing. All of that would have to happen. And-
So in your view, the defect here is, I don't mean to minimize the defect in the document. I'm just trying to get my handle on what it is from your point of view. That this document, as a document in terms of its provisions, forget the execution of it, the provisions, it could have been submitted by the conservator at the time for some kind of action or approval to the court while the conservatorship action was still open.
Yes, in fact, were I
At
counsel.
that point, if that had happened, what would and the judge found that it reflected the correct wishes, what then would have happened?
So the process, Judge, is that the petition, in this case, I would have, if I were in the situation, I would have filed a petition to expand the conservatorship to include authority to create an estate plan. The court would have issued a citation. That citation would have been served on all interested parties, the heirs at law, as well as the devotees of the original will. The circumstances of the finding of the original will, the 2006 will, are not part of the record. I'm not going to go into that. Certainly, certainly it would become involved if there were further proceedings
Okay, but
on this.
I just so want to make sure I understand. There is an order enabling the conservator to create a estate plan.
Well, not according to the conservator, because he's saying it says the opposite. He says now that that is a reservation of that privilege to create a will in the decedent. So which is it?
Okay, but there is this order dated September 6, 2017.
Right.
So can we just work with this one?
We'll work with this one, yes.
Okay, so I see that it says the conservator is, to create a financial and an estate plan
Right.
be established for Jean Olson. All right, so you were saying you would have
Yes, so the
filed a
citation.
petition, gotten this, so
There's a
this
return
was
date for
obtained.
objections. The petition itself is filed along with a copy of the proposed will. That
Okay.
has to be available for review to the judge. In most cases, a guardian ad litem is appointed to investigate and report back to the court. That guardian ad litem would definitely contact the decedent and may very well contact other individuals who are heirs or devotees, other interested parties, file a report. Then there would be a hearing. It may be an informal hearing if there are no objections filed, but there would be some kind of a hearing where a judge would officially make a substituted judgment saying that, in my view, the patient would want to execute this document as their will. They then delegate to the conservator the authority to execute the will. Now,
Okay, so all of that is what's missing here.
all of that, but there's more. Because, Judge, if you look at the language in 5407D7, it says that the conservator in executing the will must adhere to the requirements set forth in Section 2502, which is why the conservator is signing the will and the conservator is having the will witnessed. Now, this again is the indication of reliability, and along with the decree forms the extrinsic evidence that a document that is signed and witnessed, but not signed or witnessed by the testator, is in fact a valid will. There's a difference between intent and authority also, and you need both for a will. The statute, Section 1 of that statute, 2501, says that anyone who's over 18 and of sound mind can execute a will. In this particular case, Judge, we're not dealing with someone over 18 of sound mind. We're dealing with someone who arguably is not of sound mind. So there's no authority then for that person to sign a will in the absence of some other statutory authority. And that statutory authority in the case of a conservatorship is found in 5-407D7.
Now, what would be the mechanism at this point to go through the steps you just listed that didn't happen here between expansion of the authority under the in an order of the court, which did happen, and then authorization by the court of the signature? Obviously, no GAL could be appointed for Gene Olson at this point, but could you obtain sort of the functional purpose that the judge was to serve in ensuring that the document that's presented to the judge reflects her actual intentions by filing, for example, a general petition at this point?
So first off, Judge, off the top of my head, I would say that you cannot create a will for someone, regardless of the soundness of their mind, after they're dead. But
yeah,
beyond that, Judge, I do want to emphasize that in the usual practice, the will is presented to the court. In this case, it never was. So we don't
Right.
have any evidence to suggest that the judge intended, and he's the one with authority, there's no evidence that the judge intended that this document become the decedent's will.
and I understand all of that. I was asking, is there some procedural mechanism by which those steps, which were omitted, could now be taken?
I don't believe so, Judge. The probate court, there are other courts in the Commonwealth, they have general equitable powers, so you can file a petition for anything, but I don't know if there's any basis in the law that would support that kind of relief.
I don't either. I'm just asking. So could you turn then to the language of 2-502A and B, and perhaps explain what we're supposed to do with the introductory clause that says, except as provided in paragraph B?
Yes, Judge. So to contrast with what my brother is saying, he's saying that that's sort of a catch-all exception. He's saying that that applies in every single case. I'm saying in the alternative that that only applies when there's some other statutory scheme set up that creates a need for extrinsic evidence that can either serve as a surrogate for the signature and witness requirements or a supplement to the signature and witness requirements. And again, the most obvious example in this case is the very law that authorizes the court through a conservator to execute a will, because as I said, we will then have a will signed and witnessed, but not by the testator, that can only be admitted to probate with the extrinsic evidence of the decree authorizing the execution by the conservator of that will. So that is an exception where the rules of execution cannot be applied, as opposed to a general exception proposed by my brother that says it's just anything can be admitted into probate. Now, granted, not everything may ultimately be allowed as a will that's admitted to probate, but as Your Honor, Justice Shen pointed out, even the cocktail napkin must be admitted into probate, and there must be presentation of the extrinsic evidence for the court to be able to determine whether or not that is in fact a will.
Can I ask this another way in this? I'm trying to simplify this, which just may not be possible in this case. As I understand 2502, it lists 3 requirements for a will: in writing, signed, witnessed, basically. It creates an exception as provided to all 3 as created in subsection B, or as delineated in subsection B. And that exception talks about intent, being you can prove intent by or establish it by extrinsic evidence. Can you tell me with great particularity how we are supposed to read subsection B? What precisely does it mean?
Judge, it means that in certain limited cases where the will in writing and signed and witnessed in and of itself is not sufficient to establish it as a will, or at least not sufficient to establish it as the complete will, and therefore extrinsic evidence is necessary to either establish it as a will or to complete the document as a whole will. There are a number of examples of statutes that would require that kind of a program set forth in my brief.
It would have been very helpful if our legislature wrote it that way. Your explanation makes sense, but it's not what it says.
Well, it would have been very helpful if our legislature had deleted the except for Section B part as well.
For your side.
Well, you know,
I guess what in the language of the statute supports your position, which does make sense, that subsection B is limited to the instances that you identify?
well, Judge, let me put it this way. If we don't read it in a limited fashion, if we read it in a general fashion, as my brother suggests, then pretend for a moment that I'm a person of ill repute. The first thing that I'm going to do is I'm going to go down to the Suffolk probate and start pulling the records of all the guardianships and conservatorships, and using the petition form, which lists all the interested parties, find those cases where there are no interested parties. And then I'm going to start creating a list of letters, correspondence, that's going to establish me as a dear friend, and one of those letters is going to say, Matthew, I'm leaving you everything I have. And when I'm done with that, then I'm going to set up some kind of a phishing scheme with email, and I'm going to get the lists of elders from the communities, and I'm going to be sending out emails to all of these elders saying, hey, I'll do a free will for you, or have you thought about this? And somewhere in that scheme that those internet pirates use, there's going to be language that's going to result in a document that won't be signed and won't be witnessed, but it's going to leave everything to me or my straws. I'll have to set up straws who will go be the named recipients of these, because I'll be doing this too often to keep appearing for myself. Then I'll go to the other counties in the Commonwealth. And then, because most states have legislation like Massachusetts does that says you can apply the law of other jurisdictions, I'll go to other states and I'll say, this is a will filed in Rhode Island that falls under Massachusetts law, and I'll repeat the whole thing.
Okay, so for us to agree with you, we would first have to find the statute ambiguous, correct? And then
Judge,
we would have
find
to
that it doesn't make sense.
Well, no, I mean, if it's unambiguous, it's unambiguous, whether it makes sense or not. So we would have to
Also-
first say it's ambiguous and then conclude it doesn't make sense to interpret it the way the conservator argues.
Judge, ambiguous in the sense that it doesn't make sense in the overall scheme of the statute, and I think I've set those arguments forth in my brief also. It's not a workable solution. It's not something that promulgates any of the stated goals of the UPC. It doesn't make things easier to identify.
I don't understand that at all. Subsection B is intended to elicit evidence of the testator's intent, and Section 501 or 2, whatever it is, says that one of the primary purposes of the MUPC is to effectuate the wishes of the intent of the decedent. So,
Section B doesn't say that it's there to address the testamentary intent of the decedent judge. It says intent that the document constitute the testator's will, and that's a slightly different thing. We're not talking about whether or not the will contains the testamentary intent. We're talking about whether or not the document was intended to be the will.
all right, so now I'm confused because it looks to me as though there's really no dispute that it was intended to be the will.
Well, there is a dispute. I mean, that would be a disputed fact, but the point is that this extrinsic evidence should only be allowed in those cases that there are statutory exceptions for, like the conservatorship statute, where you need that extrinsic evidence. And for that, in that case, it's actually the judge's intent that the document be the will, because the testator doesn't have the capacity, but the judge has authority. So it has to be the person with authority who has the intent that it be a will. And the intent has to be expressed. And as I said, the intent is typically expressed by a writing, signed, witnessed.
So
Unless there's a-
5407D7 requires the conservator to comply with 2502 when making a will.
Right.
for the protected person. 5407E then says that the court, in approving the exercise of powers, is to decide what was the intent of the protected person. I'm summarizing, obviously, to the extent that can be
The
ascertained.
testamentary intent is,
Okay,
yes.
so if the conservator executes a will, as he did in this case, it's not signed by the testator, what then happens under subsection E? So he hasn't complied with 2502.
Well, a will signed by the conservator that hasn't been reviewed by the court, it doesn't comply with the statute either. So it's nothing. It's not a will. It's just a document written by a conservator.
So if the conservator signs the will on behalf of the protected person, he hasn't complied with 2502, it cannot be approved by the court under 5407E?
507, I apologize, Judge. Could you read me I know 507.
So 5407E says the court, in approving a conservator's exercise of the powers listed in subsection D, shall consider primarily the decision that the protected person would have made if not disabled, to the extent that that can
Right.
be ascertained.
So
let's
that's-
say the conservator makes a will but doesn't get the testator's signature, so it does not comply with 2502. Can that be approved under 407E?
Section E is what we refer to as the substituted judgment clause.
Right.
This is not an authorization clause. It's a clause that sets out the guidelines that the judge must adhere to when making a substituted judgment. Just like the cases involving treatment with antipsychotic medications or end-of-life issues, the judge making a substituted judgment, putting him or herself in the shoes of the protected person, has to make a will that, as nearly as possible, mirrors what the protected person, him or herself, would choose. So that in of itself is not the authorization, it's just the sort of framework after the authorization has occurred as to how the will is to be created. So I don't think that Section E would provide any kind of an exception to the execution requirements in 2-502.
Maybe, let me put it another way. If this document had been submitted to the judge while Ms. Olson was still alive and approved and signed the way that it was, as we have here, that would constitute a valid will, even signed in this way, because the judge would have authorized it. Am I correct?
Yes, I'm assuming,
So
Judge,
it's not
that the citation
really-
issued
So
properly.
another way of, right, assuming all the mechanics of notice and citation had been complied with within the context of the conservatorship. So in some ways, it's not that this is defective as a will, it's because it could have been signed in this way. It's signed by a conservator in the presence of two witnesses, et cetera, et cetera. It's just that the conservator was not authorized to proceed in this way. If the conservator had been authorized to proceed in this way, this would be Ms. Olson's valid will.
Yes, setting aside the possibility that there may still have been questions about the conservator's knowledge of the prior will.
But they would have been raised within the context, but presumably because notice would have been given, that they would have been raised within the context of the conservatorship action before this will was executed.
I would say yes, Judge. If the conservator had adhered to all the requirements, including the notice provisions, and the judge had approved the proposed will, and then it was properly executed and witnessed, then yes, it would be a
And
valid
that
will.
can't be done now.
I don't see how we can do it posthumously. I've never heard of that.
Well, it's an
being done.
action, it's not really any action that the conservator's taking posthumously. All the actions were taken while the decedent was still alive. It's a question of whether the judge could somehow, nunc pro tunc, I suppose, approve of these actions at this point. And maybe in that context, you'd have all of these disputes over was she competent? Was this intent? What did he know about the previous will? All those things. I don't know. I don't know the answer. I'm just trying to sort it out in my head.
Well, again, Judge, theoretically, but with the knowledge of the pre-existing will and the conservator's duty to possession of that will and what.
Sure,
inquiries were made.
those are all legitimate questions. I guess whether, those get disposed of on a summary judgment and on a probate petition, I don't know. I don't think so, but, Let me see if there are any further questions. No. Okay, it's a fascinating case. You've presented both sides extremely well, both in your briefs and in your argument. I would appreciate it if, and cooperate so that I know there's no dispute among you, that you submit within a week all of the papers that were filed in the conservatorship, because I had questions when I was going through the record and that I couldn't figure out from that. So if you would do that, then the case is submitted. And we're going to take our morning recess, which we'll be back in about 10 minutes.
Thank you, Judge.
Welcome back, everyone. Our next case is Wesley Nagy versus Meta Nagy, case number 2023P0219. I just want to remind all counsel that the case is partially impounded, so I assume that has to do with financial information, but maybe you'll know better. In any event, please just be cautious about not referring to impounded information in open court. With that, Attorney Curhan, we're ready whenever you are.
Good morning. May it please the court, Dana Curhan representing Wesley Nagy. We challenge...
Sorry, I mispronounced that.
I didn't know it either until he told me. We challenge the property division in this case, and in particular the division of the parties' four pieces of real estate. And we essentially raise two grounds. First, by any measure, the wife received the overwhelming majority of the property. She received 3 out of the 4 properties and the 3 most valuable properties. Essentially, she got properties with generally nice and very large buildings on a total of about 5 acres. The husband got a small house on with no basement, no garage, on a 1/4 acre. But I think the more important thing is the judge picked the valuation date as of 2017, the date of their separation. So in the 4.5 years between that time and the time of judgment, the properties appreciated substantially. And
Do you agree that the selection of the valuation date or for purposes of the division of marital property is subject to judicial discretion? The judge has some discretion to determine the date on which the value of the properties is to be determined?
a judge has some discretion, but the SJC said in Connor versus Benedict that the presumptive date is the date of the trial. And there may be situations where the party claiming the assets is responsible for the gain and is largely responsible for the gain, or maybe the other party is engaged in some bad behavior, some negative financial behavior. And the judge said, look, the husband after 2017 didn't contribute to the property. Here's the problem. We agree with that. But number one, he was disabled during much of this time and was unable to work. He was asking the court for alimony, temporary alimony, and he didn't get it. So he didn't have the ability to pay. But number two, what the court did not consider was that the rental properties were generating substantial income. So the judge did not consider the probably $500,000 or more that was generated by this property by all the rental properties between 2017 and 2022. And, so yes, the wife is paying the mortgage, but she's paying the mortgage and the taxes and all these other expenses largely out of the income from the property, which he did not share. So I don't think, and number three, the appreciation and the value of the property is not because of anything she did. I mean, she didn't go and say, let's renovate these properties, let's fix them up, let's put a new building on, let's do this or do that. It was purely the market. It was pure dumb luck. And it was, there's no reason why the husband can't participate in that appreciation.
How is it an abuse of discretion when the judge added in the equalizing payment of $297,397.77, plus I think we also have to include alimony into the overall calculus of the division of the marital estate. I believe under the Alimony Reform Act, it also counts toward the overall number.
Well, I'm not sure how much alimony really factors in on this, number one. And number two, had the property been divided as of the date of the judgment, the equalizing payment would have been higher by, I think, several $100,000.
100,000, 400,000,
But you didn't,
something.
sorry, unless I'm incorrect, which I may very well be, you didn't take that number and then back out any of the expenses or costs that the wife had paid during that period, right? That's just a raw, that's just a raw number.
I'm not purporting to have the answers here, because I think it probably needs to go back for recalculation. I agree that the wife paid expenses. The wife claimed that she was losing over $1,200 a week on the rental properties. The judge said, no, you're not. And when you look at, there's a chart actually in the judge's findings where she talks about 2017 to 2019. 1 year there was a loss, and excluding depreciation, 1 year there was a loss, 2017, 2018, and 2019, there was positive cash flow. And when you add in depreciation, which the wife is now entitled to take, it's even, she gets the tax benefit, it's even more substantial.
That actually begs my next question, which is, do you dispute anything in the judge's chart?
I don't think I dispute anything in that chart. I do dispute some of the numbers in the wife's, some of the charts included in the wife's briefs. For example, there's a claim in there that the 34 Avery, where she's living, depreciated or declined in value by, I think, $89,000. I don't know. I couldn't find where that comes from.
Do you dispute your opponent's math insofar as when you consider the entire estate, including the non-real estate assets, it turns out the husband received more than 50% of the estate? Do you dispute that?
I don't dispute that. The judge said, as far as the non-real estate assets, the husband should get 60% of that. So
Right. So
but-
if you consider the entire estate, and so the judge says she finds a approximately equal division to be fair and equitable, and it turns out that the husband did, in fact, receive more than 50% of the estate. Where is the abuse of discretion?
He didn't receive more than 50% of the estate.
That's what I was asking. So your opponent says when you consider all the assets, the husband received more than 50%. You dispute that?
I dispute that because all of that depreciation is gone. The non-real estate assets, that 60% versus 40%, that is sort of in the tens of thousands, probably the low tens of thousands, but that's not in the hundreds of thousands. If you divided the real estate in 2021 or 2022, the equalizing payment might have been $300,000 or more. It might have been around $300,000 more. So that is really our contention. And, there are some collateral consequences. Essentially, when you look at the parties' contribution during the course of the marriage, yes, the wife earned more than the husband, but the husband inherited a lot of money, and most of his inheritance went into renovating not just these 4 properties, but there were 2 other properties. And he also put in a lot of sweat equity. He's a contractor. He renovated these properties. He's responsible for a substantial portion of the value of these properties. Now, the equalizing payment may reimburse him, I guess, without interest for what he put into it financially. Probably not all of it, but some of it at least. But it does not take into account his non-financial contributions to all 4 of the properties and to the 2 properties that they sold and used to pay various marital expenses and to buy some of these properties. So, the SJC tells us, and this court tells us, that we have to consider non-financial contributions, and this judgment just doesn't do it. He essentially came out of it with less than what he put into this marriage. And, for 10 years, this is a marriage of almost 30 years, but for 10 years in the middle, he was largely supporting the wife. And for other periods of time, I mean, I think she was able to earn what she earned because of his contributions. So this judgment does not take any of that into account. So I think when you look at everything, you look at the total package, there's just no reason for the way the judge handled this and for ignoring the income that the husband didn't participate in and for ignoring all of his non-financial contributions. I mean, the judge made a finding that the wife has the ability to maintain her current lifestyle. She also made a finding that the husband does not. And I think when you look at the jurisprudence of this court and the SJC, I mean, there are cases that say very clearly that a judgment is not, the purpose of a judgment is not to see one party being able to maintain their lifestyle and the other not. You know, the husband, maybe he can go back to being a contractor, but he doesn't have a place to run his business. Half of his tools went to the wife. His golf cart went to the wife, so he can't really resume golf. I think this is, when you look at everything, you know, he just doesn't have the ability to earn and accumulate assets, and there was no reason for him not to participate in the marital, fully in the marital estate. Unless there are any further questions, I will leave the remaining points to the brief.
I don't see any. Thank you very much. We've got your arguments. Is it Attorney Jackson?
Good morning, Your Honors. Attorney Jackson on behalf of Meta Elizabeth Naj, together
You're
with
going to
Peter-
need to speak up, please.
Good morning, Your Honors. Linda Jackson on behalf of Meta Elizabeth Naj, the appellee, together with Peter Cooperstein. Your Honors, the trial judge did not abuse her discretion in awarding the wife 3 of the 4 properties and selecting a valuation date and a date of division as of the party separation, which is about 4.5 years between the separation and the date of the first trial. This is an instance where the parties had no children, there was no economic partnership between them as of the date of separation, and there was no marital partnership either. The husband actually left the residence, the primary residence, moved in with his girlfriend to a house in Chilmark, began paying 1/2 of those utilities at the girlfriend's family's house, and worked at her family's property for free. He didn't need alimony at the time the complaint for divorce was filed.
So the support the judge cites for picking a date other than the date of the judgment for division of for calculating the value of for purposes of the division of the marital assets is Civitas versus Civitas. What were the facts in that case?
The facts in the Civitas case was that that involved a dealership. That involved a fact where the husband was actually contributing quite generously to the wife during the party separation, and that the wife did not participate in any of the increased value related to his business post-separation.
The business was actually created after the separation, and the wife did not participate in the activities of that business.
That's correct, Your Honor.
So that's not really this situation. These are properties that were purchased during the marriage with funds that were contributed by both parties, but not insignificantly by the husband, and where the increase in the value was not tied, at least according to the judge's findings, to any efforts by the wife. She was maintaining them for sure, but the judge did not find that the increase in the value of those properties was due to her efforts. Instead, it appears that the increase in value was an increase in market value enjoyed by the real estate market as a whole. So is there a case that's, let's say, better support for this kind of factual situation than Civitas versus Civitas?
Well, I think there is case law that supports an unequal division of the marital estate.
But I'm not asking about that. I'm asking about what we've got here, which is where let's say the gain, the gain is due to an external force, not to an effort by either party.
I would say no, that I'm not aware of a case where there would be a different result based upon.
Because normally, just the way I understand it, normally you avoid this problem by valuing the properties as of the date of the divorce.
Well, this is a unique case. First of all, the wife really did participate in the preservation of the assets. If it wasn't for the wife's additional actions, not only did she improve 50 Old Lighthouse Road by renovating about $60,000 worth of renovating a shed into an actual rental property, but she maintained the rental business, and that was a lot of extra work. I mean, the husband actually had actions that made it more difficult during the party separation for her to do that. I mean, at one point, his girlfriend was drinking, he was on the property, there was an incident with a tenant, the police came, and Airbnb actually shut down the advertisement. That was one situation. But the wife was responsible for obtaining these tenants, whether they through her medical practice or they were through Airbnb. She wrote the leases, she showed up, she did the turnovers. Oftentimes she did the cleaning as well, in addition to all of the maintenance. I mean, if it wasn't for the wife's sole efforts, these properties wouldn't have all existed at the time of the trial. As you can see, their budget was very, very tight.
But did the judge, as I understand the Civitas case, and the judge quoted from it in the opinion, it tells us that a court may prevent a spouse from sharing in post-separation increase in asset value where, quote, the increase in value was solely attributable to the other spouse's efforts. I didn't see that the judge made a finding that the increase in value was solely attributable to the other spouse's efforts. The judge said instead, the year of separation 2017 has been selected because husband did not contribute financially to the marriage after this date. So I'm a little troubled that the judge didn't make the requisite finding.
So I think the court needs to look at the judgment as a whole. The husband received a larger portion in the non-real property assets. He also received that equalization payment of about $297,000, and he also received alimony. Also, at the time of the trial, there were only 3 properties that had any appreciated value, and he obtained the appreciated value in one of those properties. I mean, the standard for property division is an equitable division of the marital estate, not necessarily an equal division. And in this case, looking at the judge's 44-page detailed findings of each and every factor, that the end result was an equitable result. In regards to the equipment issue, this was a husband that hadn't worked in the construction business since 2020. He was awarded 2 larger pieces of construction equipment, 1 tractor and another piece of equipment. He was awarded a property where he could store the equipment in a storage bin, which is what he had been doing at 25 and 34 Averill. He had the ability to use a brand new, newly renovated 3-room rental to store his equipment if he had chosen to be working in construction. And he received $38,000 worth of the equipment. The wife only received her medical equipment, which was valued at $17,000. And then the judge even gave the husband the election. He had the right to elect to buy the wife out of the remaining hand tools, which the 50% value of those was about $6,000.
So to make sure I understand what your position, were we to conclude, hypothetically, that the judge picked the wrong date for valuing the real estate, your position is that we would still affirm because if you look at the entire estate, it's still approximately an equitable division?
Absolutely.
So your opponent disputes your math, so how are we going to do that without doing the math ourselves?
Well, one item that he disputed was that it depreciated value on 34 Averill, and I would like to point out to the court that the wife on her own refinanced during the pendency of the divorce matter the property at 34 Averill, and she generated about $230,000 in proceeds, of which during the pendency of the divorce matter, through agreement of the parties in council and subsequent court order, the husband received $145,000, and the wife had received about $80,000.
Aren't these findings that have to be made by the judge?
Those findings, I believe, are in her findings of fact. I think it's on page 23 of the brief.
But how would we be able to do, we would need to know both the increase in the, in value of the properties between the date the judge used and the date of the judgment, and then get a handle on all of the costs and revenue associated with those properties, and get a handle on who bore or benefited from those costs and revenue, and then compare those numbers with the market value increase to find out whether the overall division of the marital estate was equitable. Isn't that what would need to be done?
Well, I think the parties stipulated to the values of the real estate as of 2017 and 2021, so I think the court did have the 2021 values available to them, and all of the wife's financial documentation and what the wife had paid, and bank account statements and invoices. We had forensic accountants. I mean, we had 7 days of trial. I think all of that financial evidence in terms of what the wife actually paid for, because the rents did not cover all those mortgages on 4 properties. Also, one of the reasons why she was awarded all 3 properties was simply because she was in her 60s.
So how much was the shortfall between rent and the amount the wife was obligated to pay to keep the properties going?
It was significant, but I do not have that number as of this moment.
Okay, so let's just say it's under $100,000, the shortfall.
Probably.
Okay, and the embedded gain due to market forces was what?
On the vineyard at that time, I don't know.
I thought you
know
said the
that-
parties had stipulated to it.
There were values at the time of trial as to
Okay, so.
2021.
And what was the difference? It was like $500,000 or something? No.
I think the difference was more like, it was under $500,000. I think it was closer to $250,000.
The difference between
This
the value
2017
in 2017
and the
date of-
2021, after the wife refinanced the property at 34 Averill. But one of the problems in this
So
case,
it was how much?
I think it was closer, it was under $500,000. I think it was closer to maybe $250,000.
Okay, whatever number it wasn't 100,000.
Correct.
So she's getting the benefit of the difference between whatever she was out of pocket for carrying the costs, carrying the properties, and the amount of embedded market gain.
And all the work that she did during the entire separation to obtain
Sure.
those rentals.
Again, that's not quantified in any amount.
Also, the party's intent, and I think the court's intent in awarding the wife these properties is she was the primary breadwinner. She also had a medical illness. She also was practicing medicine in the area of environmental illness. And the marital residence that she lived in and the property next door at 25 Averill, which is only 500 feet away from the marital property, were renovated with specific specifications that made it a safe and healthy environment for someone that has chemical sensitivities. And then part of her business in having a boutique medical practice on the vineyard was people would fly in and some of her patients would rent there. And that was the primary, that's how she was the primary breadwinner. And she's in moderately poor health. She's in her 60s. And there's a husband that's requesting alimony that actually was, did receive an alimony. The wife needs those properties, both Knoyer to run her business, 34 able to live in a safe environment, and 25 able not only to live in a safe environment since it's so closely next to her home physically, but also to engage rentals oftentimes for her patients who are also chemically sensitive and sick. So that was the party's intent in even building these homes. So it was equitable in the end for the wife to receive those three, and she really struggled to be able to buy the husband out. And in the judge's findings, the wife did even obtain, I think, $100,000 from her sister, and she utilized those funds to assist her in buying out the husband and giving him that $297,000 lump sum payment. But the equipment that he received 60% of, is significant value. And, it was more than twice, I think, the value of the small equipment value that the wife received. So I just think that the importance of the final judgment is that under the circumstances, it is equitable.
Let me see if there are any questions. I think we understand your argument. We have your brief. And I thank you both for your arguments and your written submissions. And with that, the case is submitted.
Thank you, Your Honors.
The last case on our list for the morning is 2022 P1060 Harris Auto Body versus Commerce Insurance Company. Is that Attorney Garrick? We're ready whenever you are.
Good morning, and may it please the court. Joshua Garrick on behalf of Harris Auto Body, Douglas Haddad, and Alexander Haddad. This case is not about whether or not the judge in the Worcester case should have or should not have approved the settlement agreement. Instead, we're here on a very narrow issue, which is, can Commerce avoid a decision on the merits yet again by having a case dismissed at the 12B6 stage on the collateral estoppel issue? It was error for the Superior Court judge to do that because in this case, Commerce has failed to meet its burden in two respects. First, it failed to prove that the issue decided in the motion to enforce the settlement was essential to the underlying fraud-based claims in the Worcester case.
But you've got to be careful because that's not what the first step in collateral estoppel actually is. It's whether it was essential to the judgment. And I think, wouldn't we have to agree that the decision on the motion to enforce the settlement was essential to the judgment?
So the Supreme Judicial Court addressed that very issue in the Giroux versus Palmer case, and in that decision, they grappled with, well, is it the case, the underlying merits of the case, or just the issue at the time? And I think that when you talk about the essentiality element, the key language in the Giroux decision to show that the decision on the motion to disqualify wasn't essential is where they say Giroux could have prevailed on those claims regardless of the outcome of the motion. So if the counsel was disqualified, they could have hired other counsel and pursued it.
But we don't have a motion for disqualification here. It's a totally different situation.
Sure, but
if a motion to allow us to enforce a settlement is allowed, that's dispositive of the underlying claims, and it's essential to the judgment. I don't see how it can be anything but those two things.
Well, because we're dealing with a issue preclusion, not a claim preclusion claim. Here the issue is the finding that the settlement agreement should be enforced, is that essential to the underlying claims?
Essential to the judgment.
Well, respectfully, Your Honor, the Giroux case says that it has to.
In the context of a motion to disqualify counsel.
Well,
All right. Do you have a case other than Giroux?
No, sure. Well, in
That-
addition to Giroux's, there are the other cases that are cited in the Giroux's case. Each one of them goes to the case, the underlying merits of the case or the controversy. That includes the homeowner's case, where the first case was where the bank sued to recover for damages to a fire. And then the second case was suing because there was no coverage. In the first case, the position was taken that there was coverage that was in place, and so that issue was given preclusive effect in the second case. The Green case, that was the civil service case, where a finding was made in the civil service context that the termination of the employee was lawful, and the subsequent case had to deal with emotional distress claims in a workers' comp context. Again, that went to the underlying merits.
And in all of those cases, what was the nature of the judgment? It was a judgment on the merits of the claims, right?
Correct.
So doesn't it matter what the nature of the judgment is when we're determining essentiality?
So the judgment here was a judgment of dismissal. So there's no finding that my client had done anything wrong on the merits. And on each of these other cases, the homeowner's case.
And I agree with that, but the nature of the judgment is what matters. So for purposes of the essentiality requirement, right? So let's say a judgment of dismissal enters because the court finds there's no personal jurisdiction, right? So the memorandum opinion on personal jurisdiction would be essential to the judgment of dismissal, would it not? It's not, it doesn't relate to the merits of the underlying claims, but it's still essential to the judgment.
Well, I think that the distinction the way I would respond to that, Justice Chan, is to say that in a case like that, the preclusive effect would not be an issue preclusion, it would be a claim preclusion. Because if there's a lack of personal jurisdiction or something along those lines where the judgment entered on those grounds, that you can't just simply refile that case somewhere else because there is a definitive finding on the merits. Here, the case on the merits had to do with insurance fraud. There's no finding whatsoever. In fact, the settlement agreement that was proposed that they try to enforce so desperately, the language that they use, which is attached to the addendum to our reply, says this is not based on the merits. This is solely to avoid the uncertainties of litigation and to avoid ongoing litigation costs.
Okay, but it's still, the judgment still acts. Why is it that the effect of this judgment is not controlled by Rule 41 B3? B3.
Sorry?
B3.
Right, so the question is why?
I'm looking at the language.
Yeah.
And I don't understand why this case doesn't fall under any involuntary dismissal not provided for in this rule, other than a dismissal for lack of jurisdiction, for improper venue, or for failure to join a party under Rule 19, for improper amount of damages in the Superior Court or in the District Court, operates as an adjudication on the merits.
Yes, and the reason why that doesn't apply is because that would apply to a claim preclusion analysis, not to an issue. We're not seeking here saying, well, we want to avoid the judgment. That's not what we're here doing. All we're saying is that the factual issue, which was based on an interlocutory order, no longer exists. So the claim itself could be extinguished by Rule 41, but that's not the inquiry for this court. The inquiry for this court is the issue that Commerce is seeking to preclude us from relitigating, is that precluded? And under the...
Well, your issue is you want a declaratory judgment as to the contents of the settlement agreement.
No, well, that's not necessary. The declaratory judgment action was to determine, is there an obligation? It wasn't to...
What declaration are you seeking in the DEC action? Declaration that what?
The declaration was that we're not bound to any of the terms. And the reason why...
Because no contract exists, right?
Essentially.
Okay. And what was the basis for the judgment in the underlying case? What was the basis for dismissal of the prior litigation? Let's start with that.
The underlying case was dismissed because the parties didn't submit an agreement for judgment or a stipulation of dismissal.
And had previously reported that the case was settled.
and that's all the parties did, and we agree to that. We agree that the parties had reported the case settled, but at that same hearing, and again, I don't want to digress into the facts of that because that's our argument below. But at that same hearing, counsel both for Commerce and for all of the Harris parties said, look, if we recognize that we may not consummate this deal, and so we're going to be right back here in 30 days if we can't settle.
Do you agree that but for the judge's determination that a contract existed, that the settlement agreement was a binding contract, but for that determination, the case doesn't get dismissed, right?
But for the decision, the case doesn't get dismissed. I would agree with that. That without that finding, the case would have remained active. And they could have filed a motion to set.
So isn't that the definition of something that was essential to the judgment?
It's essential to the conclusion of the case. It's not essential to the underlying claims. And I think.
But I didn't ask that. I asked isn't that the definition of something that's conclusive or essential to the judgment?
Well, I would answer that question, yes.
Yes.
I agree, but that's not the standard under Giroux, and again, Giroux couldn't be clear. The finding must be regarded by the court and the party as essential, merely essential to a determination of the narrow issue before the court at the time, and that's why we're here. That by the rule of the SJC in the Giroux case, if the standard was it had to be essential to the judgment, like the hypothetical question you just asked, then yes, we wouldn't be here. We wouldn't have filed the declaratory judgment action. We took reliance on the Giroux case to say that the factual finding that there's a contract, which we obviously respectfully disagree with, we took the fact that established law under the Giroux case said as long as it's not essential to the claims at issue in that case, the fraud-based claims, which, by the way, they've come nowhere near proving, that's why we did what we did. We had already filed an appeal.
But the only declaratory judgment, the only declaration you're seeking here is as to the validity of the settlement agreement. You're not looking to, right? It's just a declaratory judgment action, the second case.
Correct. What
in
are
which
our
you're
obligations?
seeking right. So how is it that even if we were to accept your reading of the Giroux case, how is it that the ruling on the motion to enforce the settlement is not dispositive of your declaratory judgment claim here?
For a number of reasons. Number one, because it was ordered on an interlocutory basis, that decision is now a legal nullity. And we cited numerous cases in our brief. I think the clearest case is the care and protection of Joe Zolito. There was a determination below that the father was an unfit parent. And then later on, they dismissed the case, and the father's like, wait a minute, I don't want this order out there saying I'm an unfit parent.
Was it dismissed in a way that would fall under 41B3?
I don't know exactly the mechanism.
But that's important because the different subsections of Rule 41 have different consequences.
Well, again, I don't read 41B3 as saying, when it says the merits, what it's saying is for purposes of can you refile that claim, you can't do it again. But for purposes of issue preclusion, where we're talking about an interlocutory order which becomes null and void by operation of law, you can't just say, all right, well, the claim goes away, but so does that issue, because then you have a Joe Zolito issue.
Would you agree, I'm sorry to interrupt
Yeah,
you,
no
but
problem.
would you agree that in the underlying litigation or the prior litigation, so neither party agreed to a stipulation of dismissal and the judge ultimately dismissed it. So would you agree that that was an involuntary dismissal of the case?
So there's case law, I think it's the Morgan case, that says that a dismissal, that it would be essentially a involuntary dismissal of the case.
That's helpful. Thank you.
But in this instance, I don't know if your question is going to whether or not we have appellate rights based on that involuntary dismissal. I think the court should recognize that, we obviously disagreed with the decision. We appealed the decision. We came up to the appeals court. The appeals court, for lack of a better word, remanded back to Judge Sullivan to make a decision one way or the other. So at that point in time, when the judgment entered for dismissal, in which by the result of that being the interlocutory order is now a nullity, and the dismissal being in our favor.
Honestly, counsel, I don't understand what you mean by the interlocutory order is a nullity.
Yeah.
And anything that precedes a judgment is interlocutory, right?
Yes.
So let's say you move for summary judgment, and the court grants that motion and issues a memorandum opinion. That's interlocutory. And then judgment enters granting summary judgment. What do you mean by the underlying order becomes a nullity?
So any findings that were made before the entry of judgment, unless they're included as part of that judgment, go away.
So the judgment says summary judgment granted, and there's an underlying decision that makes findings. So you're saying none of that has preclusive effect?
No, the difference is that that summary judgment was granted, so that becomes a final judgment as opposed to the interlocutory findings. So here, there's anything, right? Temporary orders in a divorce case, the Joselito, the parental unfitness. These are all examples of cases where.
But this is a dispositive motion. A motion to enforce a settlement is a dispositive motion, because if the judge finds that there's a settlement agreement that was reached, that ends the case.
Fine, so the claim gets extinguished.
And then it's involuntarily dismissed, and it falls under Rule 41B3, which says that that judgment operates on the merits, as an adjudication on the merits.
Right, and so at that point in time, two things happen. The claim is extinguished, so you can't re-litigate the claim, because 41B3 says that's a finding on the merits. But the second thing that happens is
and your argument, if you have one, that the settlement is not binding or valid or whatever, you could then appeal at that point.
Which we did.
Okay, and then that appeal.
The appeal was dismissed by agreement of the parties.
Okay, agreement of the parties. That's, I think, with prejudice, essentially. Once you decide to do that, you're bound by it. So how does this become then anything other than an attempt to make a collateral attack on a judgment that you decided to no longer appeal from?
Because you're talking about a claim, not the fact. The issue is not whether the claim should be retried. The issue is, was this finding that a contract was entered? Now, here's the difference.
Okay, your time has expired, so I'm just going to see if there are any questions.
No, I'd just like to hear the rest of his answer.
Okay. No, so we'd like to hear the remainder of your answer.
So the remainder of the answer is that CP 200 tells you that you can do that. It says that you can do a collateral challenge. You can move for summary judgment. It says if you prevail on a motion to enforce a settlement, one of the options is you can then file for summary judgment. So there's all sorts of things that you can do after the finding was made, and that's all under the CP 200 case.
Okay, no? Yep. Thank you.
Thank you. I appreciate your time.
Is it Attorney Ganem?
Yes. May it please the court. Your honors, I am Glenda Ganem, and I have the privilege of representing the appellee today, Commerce, in this matter. I do want to start my argument where we just left off with CP 200, because I think it is where the appellant spends the most amount of time trying to argue their case. And the key distinguishing factor, and I think Justice Shin has touched on this but needs to be articulated, is that in CP 200, it is the denial of a motion to enforce, not the allowance. And the key distinction there is when the motion is denied, the case continues. So of course, there could be a motion for summary judgment. There could be many different opportunities to present the facts and the claims, as my brother has just argued. But here, where there is a dispositive motion that is well-briefed, argued, over 50 exhibits from every party presented to the court, a 15-page memorandum of decision, not only did Judge Sullivan articulate it once that this was a judgment on the merits and resolve the case, the appeals court actually made a finding that the motion to allow, the allowance of the motion to enforce was also effectively the conclusion of the litigation, and invited the Harris parties to a second bite at an appeal, and didn't agree with us, actually, and then said to the Harris parties, we're going to remand for all intents and purposes, have the judge enter in Worcester a judgment, an involuntary dismissal, as the court points out, under 41B3, which resolved the merits, and then invited them by a certain date to provide a status and whether or not they intended on pursuing the appeal. What the Harris parties did then was dismiss their own appeal with prejudice.
So was the judge's determination that the settlement agreement was enforceable appealable?
Yes, and the appeals court said so.
At what point was it appealable?
Well, at the point that the initial judgment was entered, what happened was there was a procedural,
I understand what happened. I'm just, my question's very specific. At what point was it appealable?
When judgment entered.
The first judgment, the second judgment, or both?
It could be both. And I don't think the appeals court made a distinction because the appeals court invited the appeal once the judgment was entered and asked for a specific status from the Harris parties, because I think the appeals court was concerned with the issue, and far be it from me to know, but the issue of finality. And was this reviewable? And so here was another opportunity for the Harris parties to seek review. They chose not to do that. And as this court points out, there's only one prayer for relief in the Middlesex action, which is to undo the settlement agreement. There's nothing else. And then it asks for attorney's fees and costs. But in terms of a substantive request for relief in Middlesex, and the Judge Saruf there pointed to the Miller case, which is factually directly on point. It speaks to a motion not to disqualify counsel, not about whether it was a fit parent. It literally tracks the issue of whether or not a motion to enforce a settlement agreement is binding in that sense. And so it's well briefed. And I think what Jaros does, which I think is interesting, is gives a roadmap, but in a different circumstance and in a different condition. But the SJC talks about the fact that it doesn't have to be a judgment in that traditional sense. So Justice Nyman, to your question, it doesn't have to be that particular judgment, 41B3. Even the allowance of that motion, which would necessarily result in a judgment, could be that judgment in the less traditional or less strictest sense. There is an expansion, unlike res judicata, which really follows that 4 points, make it or you don't. There has been an expansion in these decisions about what constitutes a judgment, how do we construe a judgment, and in this point, when the motion to enforce is allowed, there's nothing left to decide.
But so you filed a cross appeal from that first judgment, right? And that's, I'm assuming, because the judgment didn't enter in accordance with what you wanted it to say, right? So, I mean, on its face, a judgment of dismissal of the plaintiff's complaint does look like it's favorable to the defendant and not the plaintiff.
Well, so the reason we filed the cross appeal was because the appeal was taken during the Nisei period. So because it was taken during that period of time where there had that original entry of Nisei was ordered, and then we hadn't yet gotten a judgment from the court, we wanted to make sure to preserve.
I thought the judgment entered in October of 2021, dismissing the case without prejudice, and then you emailed, maybe not you personally, but on November 15th, asking Harris parties whether they were pursuing their appeal, and that same day, when the 30-day appeal period was about to run, Commerce filed a cross appeal. So that was after the judgment.
Without prejudice, correct.
Right. So
Yes.
and I'm assuming that's because of the form of the judgment, right? That you filed a cross appeal?
No,
Okay.
was to protect the interest should an issue be raised on appeal that we had not yet been made aware of, because the judgment in its formality, and we actually asked the court to enter judgment, and then the appeals court instructed the court to enter judgment, which then the court did. And we actually asked and filed the motion for entry of judgment because...
So let's say there was an order from this court because the appeal from the Harris parties was filed before judgment entered, and there was an order from this court saying that once judgment dismissing the plaintiff's complaint enters, you can file a new notice of appeal to the Harris parties. If there had not been that intervening order from us and there was a dismissal of the plaintiff's complaint, should the defendant know that they're supposed to appeal that? Because the form of the judgment to me seems to be maybe not technically correct here.
So I think it's an interesting question, but what had happened was the Superior Court stayed the proceedings, which required the appeals court to then make that order.
Right.
So there would have been no opportunity for the appeals court to ignore what was transpiring because that matter had been stayed. Once the matter was stayed, it seemed to be an invitation to the court to then say, okay, this is what you need to do. These are our instructions. Please do so however you see fit. They didn't order that it was a 41B3. And then at that second point where the 41B3 is entered, there's another opportunity for appeal. Each and every time there is an opportunity for review or it was reviewable, and instead the Harris parties made the decision to seek another forum. And exactly as we've stated in our brief and as case law, in order to undo, because even in the oral argument, Judge Saroof said, what do I do if I don't allow this motion to dismiss? What is the evidence? Isn't the evidence whether or not there was a settlement agreement, what the parties intended by the terms of the agreement? Hasn't that already been decided by the court? What is a trial in this case going to be about? There really was no answer to that. And in fact, the court comments in their final paragraph about that novel type of approach to collaterally attack a decision from another court. As novel as it was, it still fails the test for collateral estoppel and therefore was barred.
In terms of the finality element of collateral estoppel, does our case law or the SJCs make any distinction between dismissals with prejudice and dismissals without prejudice?
It does not. And in fact, the case that's relied upon, this Jaros case, speaks about judgments, as I was earlier articulating about, that judgment isn't in its most traditional or strict sense. I just want to make sure my notes are correct about that, Your Honor. With that said, I don't have any further argument other than what's briefed and included in by way of appendixes and the record. I will point the court, though, to the record appendix starting at page 300, because I think that Judge Sullivan took the second opportunity to ensure that all parties understood, even when we were looking for a motion for entry of judgment. But Judge Sullivan took an important step to say, this is what I found, again. Not that she had wavered from it, not that it was somehow dissolved, not that that order is a nullity. It was specifically restated, and in the order, the judgment of dismissal is against the defendants. So when my brother briefs and says that Commerce is the aggrieved party, that judgment didn't enter against Commerce. That judgment entered against the persons opposing the enforcement of the settlement agreement, and that was only some of the defendants, not all.
Unless you have anything further to add, we don't have any questions here. So, and we'll take the case as the remainder of your arguments is presented in your brief. With that, the case is submitted. Thank you both for your arguments.
Thank you, Your Honors.
And that concludes our sitting for today. Thank you to all of our court personnel for making this morning's session so well run, and the court is in recess.